now I think it's time to get started. Guoyu Wang will be our moderator this afternoon. And before we officially started, I'd like to thank the director of this event, the EC Beijing, the International Space Science Institute Beijing, and Nanjing Economic Zone, Nanjing 经济开发区. We thank their help to support this event, and also thank you, your speakers, to support this event. Now, Guoyu, it's yours. Thank you.
Thank you, Qianhong. Thank you for the invitation and for organizing such an event. You know, that the first one in the new year. And I also thank Antonino and Matthias, of course, for your participants. Because I'm also the legal consultant of Region Space. So thank you very much for the support of this discussion. And I'd like to share my screen now. Hold on a second, please. So I think maybe just make it a little bit smaller. Otherwise, hold on a second. Is it okay for all of you about this? All right. Good.
It's
so,
okay on my end. Yeah.
Great.
So okay.
Good. I'd like to talk some like basic legal issues regarding space resources exploration and exploitation. Actually, this is the presentation I gave in the ISL ECSL symposium at the beginning of the legal subcommittee session in 2019. But I just made, of course, some minor changes. Already 2 years passed, but we can see the space resources, I mean, the exploration legal issues is a super hot topic in the over, we say 7 years, maybe. There's so many international initiatives and projects regarding, you know, how to facilitate, how to formulate international regime for the space resources activity. And it is also my super pleasure and honor to, you know, just working together with our participants, panelists here, with Matthias in the Hague working group, as well as Antonino, and also we work together in the GADGESLA project. And I believe that Antonino would introduce the EAGLE project initiated by herself later on. So in this presentation, I just would like to introduce the legal resolution, I mean, the solution, both from Lex Lata and Lex Ferenda. These years recently, I mean, in recent years, there are some suggestions to kind of reopen the Moon Agreement, of course, but it's an option there. I would like to discuss some principles and rules under the Moon Agreement as well in this presentation. So I just try to raise some basic questions. I see, I just raised the 6 questions, and with 18 short conclusions in this short presentation. So just from 2 aspects, of course, the first one is talking about the basic principles. I believe it would be mentioned by Antonino later on as well. The basic principles in the existing space legal framework regarding space resources activities, respectively, the exploration, freedom of exploration, the use of outer space, and net appropriation, and for the benefits and in the interest of all countries. And then just talk a little bit about what should the law be in future. Is a space law in Lex Ferenda regarding the approaches, possible approaches to move on, and whether we need a primary principle at hand at this stage. to facilitate, I mean, the further discussion and the mechanism, rules, and technical standards to be discussed. So first, regarding the basic principles of space law in lex lata regarding space resources activity. So the first question is that does current international space law allow for exploration, use, and exploitation of space resources? I heard the discussion in Copulus several years ago. I believe some delegations, they still hold different opinions there. And the legal basis is that the exploitation of natural resources in space is not expressly stipulated in the Outer Space Treaty. So, of course, that's brings another question: what would be the distinction between, I mean, literally exploration and use, and the term exploitation? I had this question, discussed maybe 7 years ago in DC when I visited, the GW, the Space Policy Institute. I believe that even for English speaker, there might be some differences there. So that's another question. Exploitation is expressly mentioned in the Moon Agreement. So it indicates that exploitation might have different meanings with exploration and use. It means something else. So that's the first question. But just as the Moon Agreement article, the famous Article 11 mentioned that exploitation indicates a desired international regime in future when such kind of exploitation is feasible. However, the Moon Agreement is not, ratified broadly. Only still, I think 18 countries, right, as the state parties to the Moon Agreement. So it means that it's still open question to most of the countries, who have the concerns regarding space resource activity without such a express, legal basis to support exploitation or just, in other words, the commercial space resources activities. That's, to me, is my academic opinion there. I still would like to interpret the exploration, the use just covers or includes the exploitation in the general meaning. So free to explore and use of space resources should be part of the freedom of exploration and use contained in the Outer Space Treaty. And at least the bottom line, I can say the exploitation of space resources, no matter it's a commercial one or scientific one, it is not prohibited expressly under the Outer Space Treaty. And in addition, it is allowed by the Moon Agreement. But of course, we understand, without any specific guidelines or mechanisms there. But I have to admit that you see, already 7 years after, almost 7 years after the American legislation regarding space mining, right? And at the very beginning, I heard so many criticism, or they were questioning the legality of the legislation, no matter the legislation per se, or we say the commercial space resources activities. Till now, I believe still there are some, some international experts, scholars, they are still very hesitant to accept the legality of space mining. So that's the fact. It's not a matter about legal or illegal. That's my opinion. Actually, it's a matter of, we say, proportion relation. So when we're talking about, so commercial, the legality, always say, how to say, the legality would be affected by some basic elements as shown on the slide, whether it is commercial one or scientific one. Scientific one always have less questioning than the commercial one, or whether the project is to be conducted by one state unilaterally or by an international cooperation. So obviously, international cooperation would be easier to be accepted, no matter it's a commercial one or scientific one, by the international community. And from legal perspective, of course, again, it's about sharing, right? Information sharing would be also addressed by Antonino later. Whether that project has a spirit or some solid, the solutions for the benefits and in the interest of all countries to share something with others, is also affect the legality, we say the legality, or whether that would be strong or weak, the critics on this project. And another element is about transparency, of course. The more transparent a project is, the less controversial is it. I think that's the principle. And the last one is about the regulatory framework. So the activities which would be carried on in the vacuum of a regulatory framework, then it tends to be questioned always. So the regulatory framework here, it does not necessarily mean an international regime to be well accepted by all. It also includes national legislation. So in this regard, I have to say the national legislation of the United States and Luxembourg, I think it does contributes to move towards an orderly, sound international regime in future. And the second question is about non-appropriation principle. To be honest, I also, 7 years ago, when I read the US legislation, I was also questioning. I have to think about whether it's just violates the non-appropriation principle. That's my source at the very beginning. But today, I think that's it's not a real question anymore. But of course, it's just my personal opinion. I still heard some scholars, they strongly argue that the commercial space resources activities, space mining, is to be just in the violation of non-appropriation principle. So from legal perspective, it's still to be answered. At least in Copious by the working group, right now is established. Such fundamental legal issues should be answered in a formal way. So in this case, I believe that we understand there are so many interpretations regarding this principle. It's about whether the outer space per se, including its natural resources, belongs to everyone or belongs to none, just like a legal meaning of res communis, right? Or we should have a third option. Right now I'm feeling that we might discuss around this question. Actually, it's first, I think it's not how to say. There should be kind of consensus on outspace is kind of the areas beyond the national jurisdiction, right? No objection on that. And then actually we're talking about the right or the legal characters in municipal law level. It's not a public international anymore. We're talking about actually the legal character of the rights regarding the abstracted resources. Then it's not a matter about belongs to everyone or belongs to none. So I just refer to the new agreement in this case. Property right is mentioned in Article 11 in the new agreement. I think it's clearly said that neither the surface nor the surface of the moon, nor any part thereof or national resources in place shall become property. I think that's the political and legal recognition by all delegations in 1970s, right? So that's the bottom line. That's the red line, or we say the red light, right? No ownership over natural resources in place, but it does not answer, or it does not prohibit any kinds of such kind of claims about ownership over the abstracted retrieved space resources. So then we come back to the Outer Space Treaty again, although it does not expressly mention the natural resources. But according to, as a space lawyer, we know, according to the Article 31, right, of the Vienna Convention, we are supposed to interpret this principle in good faith, right, and make everything just in order, or it's practical. So my personal view here, hold on a second, please. So the non-appropriation applies in such kind of space activities, but only applies to natural resources in place. It means that the natural resources in place shall not be appropriated. That's it. It means that we should put the natural resources in place and the natural resources to be abstracted just in different category to think about the legal conclusion in this case. And the appropriation of samples of scientific purpose has become general practice by several states, United States, Russia, Federation, and China. And the right of disposal has been set up under the Moon Agreement, although neither of them is a state party to the Moon Agreement, but some kind of subsequent states practices could be served as, their official interpretation to this principle. It could be argued in either way, of course. And the legitimacy of commercial activities, for instance, space mining, of course, right now it's not clear. But you see, this presentation was given in 2019 at that time. But today, I believe that there are less and less questions regarding the legality of commercial space activities. But I have to say, for the commercial project, they're supposed to, not comply with, but to answer the concern regarding for the benefits of all humankind, or for the benefits of all countries. So the third question is about what would be the exact, the legal meaning of this principle, whether it's monetary. It has been discussed here and there. What do the principles of space activity carried out in the interest of all countries and for the benefits of all humankind? Actually, this question was raised by our Russian colleagues during the first UN Space Law and Policy Conference in Moscow, 2018. They just asked how to ensure that space resource activity are carried out according to these principles. So my view in this case, for the benefits of all countries, it should be taken as limits. It's part of the freedom principle. It should not be taken as an independent monetary legal principle. Of course, it would be controversial, I understand. We still have so many different voices in this case. It always has a sensing of benefits sharing in certain reasonable methods. So it means like sharing of data or scientific achievements of samples and other kinds of international cooperation. I believe this has been discussed in the Hague Working Group and reflected in the building blocks. And it's also worked very well under Gadget's Law and led by Antonino. So that's the discussion about the lex lata, the three basic principles. And regarding the way forward, the first is about approach. We also realize that there are so many discussion and differences regarding the approaches, not only about the special resources activity regulatory framework, but also about like the arms race in outer space, right? The prevention of arms race in outer space, soft law or hard law. We always heard the different approaches. But as to me, the first point, principles are necessary and fundamental, but not sufficient. This question also raised by our Russian colleague, whether we need specific rules at this stage, or we only discuss some general principle. So principles is super important, but it's not enough. So I always suggest a kind of evolutionary approach, stepwise. But stepwise approach does not necessarily mean we have to discuss about soft law first. In general, it's a soft law to hard law approach. But I have to say, we always neglect the significance of interpretation of lex lata. It's not soft law approach. So when we discussed, we have so many discussions regarding guidelines, recommendations, building blocks. We are supposed to have more, pay more attention to the interpretation of lex lata. As to me, such kind of discussion should be taken, at least again, in copious for the working group, because that's the duty of that committee. And I believe it's the only authoritative platform to do so, right? Actually, at the beginning of the work of Getty's Law, I tried to to have the attention to this point. I hope we can discuss seriously about the applicability, right, or application of the existing legal framework. But we definitely, right now we just towards another direction, right? But yeah, it's to be considered by the delegations in COPUOS in the next few years. And the next conclusion is that associated closely with the development of their issues, for instance, space tour, small satellite, it means that space resources exploitation is a hot topic, but from a regulatory perspective, it is not supposed to be solved, just independently. We have to consider the commercialization of space activities as a whole. That should be the due perspective of COPUOS. But again, we already achieved a lot. I understand that the discussion in COPUOS is difficult. So in this regard, it's already achieved a lot, but it's not enough. They should, to think about the solution as a whole picture, put everything in the big picture, and try to seek for a comprehensive solution for all these commercial space activities. And next question, I believe that's the fifth question. What new specific principles might a future international legal regime of space resources activities be based on? So I talked about the CHM, the Common Heritage of Mankind, for several times. And I heard so many different opinions on that. But again, as far as I'm concerned, I still believe that we don't have a better alternative so far. If supposing we should have a basic principle as the guidance to formulate an international regime in the first place, then nothing better than Common Heritage of Mankind. Although we understand that the drafters at that time, 1970s, they have the strong, I mean, the divergence there. But at least I think we should discuss the common heritage of mankind principle, respectively. I mean, the one under the Moon Agreement and the one in future to be served as the legal basis for the international regime in future. They are different. So as to the CHM under the Moon Agreement, it should be followed by a no more, no less, I mean, the principle of the interpretation of it. So it's just it's reflected by that article per se. It said that this principle finds its expression in the provisions, actually only in the provisions of the Moon Agreement. That's the legal meaning or the dual interpretation of the Moon of the CHM in the Moon Agreement. But again, my personal understanding, so according to the relevant provisions, the CHM under the Moon Agreement just means, okay, the moon shall not be appropriated, but we have to be, should be noted that it's not common property. CHM does not mean common property. It's clear. And natural resources in place shall not become property of anyone, but might be appropriated legally by use in certain circumstances. That's also the part of the meaning of the CHM principle under the Moon Agreement. And remove the samples of its mineral or other substances for scientific purpose could be appropriated through the right of disposal. So it just triggers another also very important question, which has been neglected for a long time. That's the meaning of appropriation. I think according to the Black's Law Dictionary, appropriation does not necessarily mean an illegal one, right? There's some legal or lawful appropriation and unlawful one. But the Chinese the version of this term appropriation actually is not in the neutral position. It always means some negative evaluations there. It just sounds like it's illegal per se, appropriation, I mean the translation in Chinese. So I think that's also the first draft of the legislation of Luxembourg, Article 1. Actually, it said that should be lawfully appropriated. It is sensitive, but from legal perspective, actually, it is correct. It is correct. And they abstracted or retrieved the space resources for commercial purpose could be appropriated legally, and might become property, but shall pursue to the objectives of orderly, safe, rational management or expansion of opportunities in the use and equitable sharing, also stipulated in the Moon Agreement. So it's just a short conclusion regarding the relations between the several paragraphs under Article 11. I think the CHM is the broadest principle there, and then followed by non-appropriation principle. And the narrowest one is shall not be property. So that's the legal relations between these three, I think the legal principles under Article 11 of the Moon Agreement. Then that should be discussed again seriously. What should be the CHM in future? So my personal view, again, this principle should be deemed as a historical, dynamic, open, and developing process in international. It's not something still once for all. It's developed together with national practices, together with the legal understanding, interpretation of delegations. So we should be, to be inclusive to this principle, to make it inclusive, with different legal opinions, to make it alive, otherwise. And it should have the legal implications between common property and res communis. It's different with, it's not common property. And it also has some very substantive distinctions with res communis, actually. and should not and should be developed, recognized, and reflected in the forms of specific rights, obligations containing in cooperative agreements, soft laws, and treaties within UN framework. And the CHM principle should be served as the corner stone of a future international regime. That's I would like to say, it's not only to the Chinese delegation, that's the legal culture in China. We would be, I think most of the Chinese would be very hesitant to accept very specific rules without a clear principle in the first place. So that's the different methodology there. But I think that's also the one of many our international colleagues. But it is difficult. So that's why, including United States, they would not like to discuss about the customary international law or the Moon Agreement or common heritage of mankind, because it always means a heavy burden. It always means diplomatic, political debates, which would come out then, maybe eventually. It's a pragmatical way. I understand, but again, my personal suggestion, we cannot get a very well-recognized international regime without discussing such a basic principle. It's also the work should be done, I mean, by COPUOS, by the established working group. And the last question, what issues should this perspective regime address? Actually, it's already discussed broadly in these years in the Hague working group in Gajesla. But in general, I believe that I always suggested it should contain, I mean, the international regime should contain at least the 4 regimes or mechanisms, mechanisms. Incentive one, actually it indicates some kind of legal rights has to be given to the space actor to make sure that they have the right motivation to do so. So that's the first principle. It's followed the principle of economics, of market, of course, and the cooperative mechanisms. Super important. Why? It's not only just from the concern of technical perspective, but also political one. Cooperation is super important. And the reasonable sharing mechanism, a collaborative, of course, and like safety zone is trying to do, collaborative, coordinative, right? And reasonable sharing mechanism. I think that's the only way to be both, agreed by, developing countries and private sectors, right? That's the only way out. And as to other specific one like transparency, the duty of authorization, supervision, registration, all these have been discussed in recent years, I think. And priority rights, of course. We might discuss this later on if the time is allowed. I think neither Artemis Accords nor national legislation just clearly stipulates, the legal character of the right over the abstracted resources. It's what would be the legal meaning of this right should be further clarified, I think. But in generally, of course, it's ownership of property right. But what would be the specific legal meaning of it? Need to be clarified further. So regarding that principle, I also is inspired by Professor Bing Chen a lot. Decades ago, actually, Professor Bing Chen already pointed out, it's totally actually a matter of political will. It's not the problem of the principle per se. Common heritage of mankind is good principle, but it's just sometimes discussed in the political way. So that's why we have so many obstacles there. So at last, I think we have different drives, as the way forward. We are heading for the international regime. no matter it would be 5 years, 10 years, decades. And meanwhile, we are trying to formulate different agreements, guidelines, recommendations, right? National legislation, technical standards. But the strongest draft should be the principle. It should be solved once for all. And then we can have the specific, we can, again, from economic perspective, we can achieve that goal with, very little price. That's the meaning there. So how to try, try to make these elements, these different drives reconciled. I think that's the question to be considered by all of us. I take too much time there, but I just stop here. Thank you for your attention. Thank you.